Hi, this is Brandon Steele. Welcome to the Mainsail Financial Group podcast series, where we host industry experts and local professionals to really help share some guidance in some areas that we don't necessarily focus on day to day. Today, we want to thank Jim Davies for joining us to discuss some estate planning kind of myths and truths that are out there, and how to make sure that we minimize potential issues and that lovely probate thing that we've maybe all had to deal with once or twice. Jim's actually an estate planning attorney with Reberg Law Group. He's been practicing estate planning for 25 years now. Is that right?
That's right.
Okay. And been with Reberg for 20 years. He really helps to create estate plans with clients, whether that be through wills, trusts, beneficiary designations. And I think a big part of his process is helping to educate and really, kind of give some guidance, but also make sure that your clients feel empowered through some of these challenges that we face. Is that fair to say?
Exactly. That's right. That's what I do with all my clients, Brandon.
Great. Okay. So we're really happy to have you here. I mean, as you know, we share a similar philosophy in terms of education for our clients. So it's a good fit. 2020 has been off to this crazy start, whether it's through the virus, whether it's through the Secure Act, CARES Act. I mean, all this stuff has kind of gotten us thinking, I think, a little bit about our mortality. So I think it's a really good time to have you on just to share some thoughts, some things to consider through all this change and how we can really, I guess, make sure all the T's are crossed and I's are dotted.
Yeah, thank you. It's good to be here.
Yeah, of course. So I guess maybe to start out on the high level, I wanted to maybe get a sense of one of the most common things that you hear of, is for people to get a will. Like that's where estate planning starts. So can you maybe just start by sharing what a will does and where it's used, I guess?
Yeah, absolutely. So, I think, first of all, to say that about a third of all people, I think most studies suggest that about a third of all people have wills here in Washington State. Essentially, what a will does is it directs the assets that you own at the time of your death to go to your beneficiaries. So that's the purpose of the will, is essentially to direct the distribution of assets, and then to find the right person to then distribute that. That person is what we identify as the executor or the personal representative. So that would typically be someone within the family or friends that could help administer the estate to make sure it gets from the deceased person and then to the beneficiaries. But that's the point of the will.
Okay, perfect. And so the executor, you bring that's a term I think a lot of us may be familiar with. You mentioned someone you trust. Is that somebody, would you suggest somebody local to you as well? I mean, what are some things you would point out, I guess, when people are electing an executor?
Yeah, good question. So typically, within your documents, you would want to appoint at least a primary person. You would want to have an alternate. I think it's always good to have an alternate, and maybe even a second alternate in the event that you need a second alternate. The executor ideally should be someone who's got time to handle the estate, who can manage the time that it takes to distribute the assets and to do what steps are necessary to accomplish the role of the executor. Ideally, I like to encourage that the executor is someone that is intimately familiar with your family, that knows a little bit about you, that has the time to do it, that has the time to go through your personal belongings, that has the time to go into your home, that can take that time and then can handle each one of those assets that they have. So that's the goal that I would like to see with each one of my clients. Now, the difficulty is to try and find the right person to do that. So maybe it's the fact that you might not have somebody like that in your immediate family. Maybe you have people that are out of state. So some of the challenges that you have are determining whether or not it's that person or if it's somebody who is out of state. So usually what I like to say is start with your closest family first, and then start working out from there outside of your first scope. So if you're married, maybe having a spouse or children or grandchildren outside of that. If you're not and you're single, then who's your closest relationship? So would it be a sibling? Would it be a cousin, a nephew or a niece? And work out from there. And if you don't have people like that to do it, then inevitably you can always choose a professional to serve in that capacity. But again, with a professional, you're going to probably pay fees for that professional. So that's sort of a second option, but one that I typically would say, let's look to family and friends first.
Okay, that's great. I think that's going to be super helpful. I think one of maybe the misconceptions, and I want to maybe open it up, make sure I've got this right too. But tell me a little about how a will does or does not dictate how retirement accounts would be distributed.
Yeah, a lot of people think that just because you have a will in place, that the will directs all your assets, and that is a misnomer. That's a misunderstanding. Conversely, there are people out there that think maybe they go to provide for a specific account designation, like a retirement account, where they would go to someone like yourself. Maybe they hold an individual retirement account, and they can designate that retirement account to go to their named beneficiary just by filling out a little beneficiary designation form that you keep on file with them. So they sign that designation, they name the person as the designated beneficiary, and conversely, they think that now they've provided for that person to receive all the assets potentially. So, and that's just not correct either. So the real thing that happens is that we essentially have two plans. We have the plan that the will controls, and then we have the plan that the beneficiary designations control. So if we want to think about those things that are typically beneficiary designated, those would be things like retirement accounts, life insurance, maybe annuities. So these things, typically you'd have a beneficiary on those things. But that doesn't account for the other types of assets that you hold. Maybe those other assets would be things like a home, other investments, savings, other types of assets that you might own, like interest in companies. So all of that would typically be controlled by way of your will. And so your will directs that. So the critical thing is getting these two different plans to reconcile, to make sure that what you've done for one, at least you take into consideration what you've done for the other.
Sure. Okay. How about in absence of a will, maybe even beneficiary designations too? But that's a little harder to skip. But if someone doesn't have a will, how is that distributed?
For beneficiary designations,
No, sorry. If somebody has assets that are not set up with beneficiary designations and they do not have a will either, how is
okay.
it determined where those would go?
So typically, if you don't have a will and if you don't have beneficiary designations, then the state of Washington, if you are a resident of the state of Washington, they have a presumption as to where the assets would go. So we call that the laws of intestacy or the laws of intestate succession. And so the statute in Washington directs where those assets would go. So if you don't have a plan in place, a written plan in place, then the state has a presumption plan for you. And so they direct where those assets would go. So for things like a home, if you own your primary home and you haven't executed a will, then the state's going to assume where those assets go. It depends on whether or not you're married or not. So if you're married or not, the common thought is, well, does the state assume that my spouse gets it all? And that's not necessarily the case. The state presumes that if you have community property, assets that are community in nature, those community type assets go to a spouse. But separate property, separate assets, assets that were things like things that you were gifted or that you inherited, that actually doesn't automatically go to a spouse. A portion goes actually to your kids and a portion goes to your spouse. Mm-hmm. So it depends on if you're married. It depends on if you have kids. If you're single and you don't have kids, then the state presumes where the assets would go. They go to your closest, essentially your closest legal heirs. So if we think about heirs sort of by way of your family tree, it would be first to descendants. But if you don't have descendants, then it goes up from there to parents and then down from there if you don't have surviving parents.
Got it. Okay, perfect. So I think what I gather from that is unless, if you want to control where things go, get a will.
Yeah, so, exactly.
I think another thing that a lot, nowadays especially comes up a lot is the software packages, the will kits that you can get out there. Can you maybe talk a little bit about that, when that may be used, what it may miss or I guess, tie in to?
Yeah, sure. I think that I have people on occasion that come to me and ask me about software packages and whether or not they're appropriate in certain circumstances. And so, I think depending upon the package itself and upon the person themselves, it might indicate whether or not you want to use that. So, a package, if you want to think about a package is a very generic plan. So the company that's producing that package typically is not going to spend an inordinate amount of time being specific for each state. So they're going to develop a plan that deals with all states, not necessarily with the intricacies of each state. So when you're dealing with being a Washington resident, you have specific issues that happen as a Washington resident to administer your estate under Washington law. So you want to be very careful with those packages because they are very, very general. And they might not necessarily work for if you're a resident in Washington state. Conversely, maybe they do, but they might not as well. Mm-hmm. And then they are just very, very general. So in other words, some of the specifics of whether or not you have your named primary beneficiary, or what that primary beneficiary is deceased, and you provide for a contingent beneficiary, some of those things are not necessarily going to be addressed in a package.
Yeah.
So normally, quite frankly, I would suggest not to go down the route of a package if you really want to think about a well thought out plan and facilitate that. It really requires you to take the time to invest in that and to hire an attorney to go help facilitate the execution of the document.
Okay.
On the other end, if you're really, really young and you don't have the resources to put in place a plan and to hire an attorney, there might be reasons to think about potentially thinking about going that route, but I don't usually recommend that route for most people.
Sure. Okay. How about, another thing that we see a lot is whether through a will kit or an attorney that somebody had worked with years ago, they've got this will that they set up 20 years ago. They feel like maybe not much has changed in their world, so they don't need to update it. Can you maybe speak to that a little bit and how often maybe somebody should refresh?
Yeah, absolutely. So typically when you've executed documents, I usually recommend that you at least review your plan, usually about every 5 to 7 years on average, or when there's significant changes in your life. So if you have a birth that has happened within your family, a death, adoption, any change in familial relationships, it's helpful to review your plan to see whether or not that changed circumstance warrants a change to your own individual plan. So that can be really helpful to adjust your plan as your circumstances change. In and of itself, besides that, it just is worthwhile to review it every 5 to 7 years for the reason that legislative things happen and laws change. State of Washington has different things that their laws change on occasion. Tax laws change. And so as those state laws or tax laws change, that might change the document itself or cause you to be thinking about, are there things in the document now that I want to have in the document that wasn't there in the first place simply because of this legislative change?
Sure. Okay. That's super helpful. I think that's something that gets missed a lot. We see it a lot anyways on our end.
Yeah, and same as well as we do. I think that a lot of people think that once I have something, it's always effective, and it may still accomplish, it may still work, but it might not work to its ultimate outcome, to the greatest ability. It's just because we haven't adapted that plan to the changed circumstance.
Sure. Yeah, that makes sense. So how about while someone is living as well? So if something happened to them, they were unconscious or something like that, or just unable to make decisions for themselves, what can folks do to make sure that maybe a family member or somebody they trust, has access to their accounts or is able to help them through those periods?
Yeah, that's a great question. So normally in my line of practice, that involves helping people facilitate their documents through a power of attorney and getting a durable general power of attorney executed for them. A power of attorney is essentially a document of appointment. It essentially appoints someone to serve as your agent, to serve on your behalf. Doesn't mean that you're not acting. It simply means that you're appointing somebody else to act as well, to act on your behalf. The timing of that document can be critical to understand when it's effective. Usually it's effective either on one of two occasions. So it's typically effective on signature immediately, or it's effective only upon incapacity. And so based upon the circumstance, it may warrant something that has to be effective immediately. On the other hand, it might be to the comfort level of the person just only to execute a document that's only effective upon incapacity, only when they're not able to act.
Mm-hmm.
So it depends on the circumstance. But if you actually have a document like that, you're enabling that person to be able to pay your bills, handle your financial affairs, manage real property issues. And those documents are helpful to update, again, every 5 to 7 years because of changed circumstances.
Sure.
That can really help you to be able to have somebody step into your shoes if you need to have that at some point in time.
Mm-hmm. Okay, great. To switch gears here a little bit, we talked about the Secure Act earlier. From your perspective, this is something we've been talking to our clients quite a bit about, but I'd love to hear it from your side of the table as well. What are some things that people should be looking at with the Secure Act and things that maybe they can do to plan for these new legislation, these new laws that are in place, to maybe help minimize taxes to heirs or create a little more flexibility?
Yeah, I think that the overall idea of the Secure Act now, the big thing that we're seeing with the Act, for people that don't know necessarily the Secure Act, one of the essential big things of the Secure Act, what it has done is effective this year. It's limited when you reach age 70 and a half, originally you had to start taking out required minimum distributions out of your retirement accounts. So the new Secure Act essentially has increased that to age 72. So that beginning at the age of 72, you have to start taking out required minimum distributions out of the retirement account. What it has done, though, is it has essentially limited the maximum deferral for taking required minimum distributions out beyond your life. So whereas historically, you could even potentially, like a child, as a child beneficiary, you could take that retirement account and slowly take the retirement account out over your life expectancy to minimize the taxes on that.
Mm-hmm.
Now, traditionally, you can only take it out no longer than over a 10-year period of time. So where it comes into us, where we're looking at it is from a couple standpoints. One, do we use trust? Can we use trust as a means of receiving these funds? And that's something that we're looking at. And then in addition, just being aware that the acceleration of these assets into one's hands over a 10-year period of time is definitely impacting individual beneficiaries and impacting their own plans too. So we're addressing it not only from the standpoint of the owner of the retirement account, but from the beneficiary's perspective as well.
Okay, that's great. And when you say trust as the potential, recipient, it sounds like there's still some things to shake out, but the idea being that that's no longer a person, am I following you correctly?
Yeah, that is correct. So there is a very complex set of rules when it comes to required minimum distributions out of retirement accounts. But the gist of that is that those required minimum distributions can be made to people and not to trusts in general. Now there is and has been an exception to that for certain types of trusts, where certain types of trusts can essentially be looked at as though they are people for determining the amount of years to pay out that individual required minimum distribution to. Though there are exceptions under the new Secure Act that allow the stretch out to still continue to occur under certain circumstances. And so what we're looking at as practitioners is to determine, okay, now with these new rules, how does that interplay with trusts now? Do trusts still qualify to allow that stretch out to occur? Do they not? I think we're expecting that the rules will be that they do, but we don't know yet. The Act just came into being. We know that there's going to be interpretation of the Act. We know that there's going to be further promulgation of the Act or legislation dealing with the Act, regulations. And so we're waiting to see exactly what the government is saying, how they're going to enact the actual new code sections that deal with the Secure Act.
Yeah. Okay. That's great. I think, it's funny. I think when these things come out, people that may not be as ingrained in this stuff as we are think that, it's like, okay, it comes out and the rule's the rule. But the truth is it takes some time to shake some of this stuff out and find out, what the actual impact's going to be. So that's super helpful.
Exactly. And I would tell your clients too, Brandon, just to, keep an eye on the news and stay tuned to that, because I think that's that we expect this is going to happen,
Mhm.
and there's going to be interpretations of the act, and it's going to happen over the next couple of years. I would highly guess.
Sure. Okay. That's great. And I think a lot of that conversation starts to move us a little more into the estate planning from a tax perspective,
Hmm.
minimizing your estate, let's put it that way.
Yeah.
When we start talking about trusts and things like that, a lot of times that can be a benefit, obviously, is to potentially minimize your estate and the tax impacts moving forward.
Yeah.
So to switch gears here a little bit, I think a lot of folks may be familiar with the federal estate exemption. I think that's talked about a little bit more, but I think very few know that we also have a Washington state estate tax.
Hmm.
So can you maybe speak to that a little bit?
Yeah, so to understand, yes, we do. We have a standalone Washington state estate tax. The reason I think most people may not, or a lot of people may not, is historically we haven't had a standalone estate tax. Washington was what we call a pickup tax for decades, where Washington was essentially allotted. Upon our own election, we essentially picked up a part of the federal estate tax that was due. Well, there was a decoupling by federal statute of the federal estate tax from states being authorized to pick up part of the federal amount due. And when that happened, then the state of Washington essentially created their own standalone estate tax. So the standalone estate tax is like the federal estate tax, but we actually have, if you're a Washington resident, you actually have two estate taxes. You have the federal estate tax and the state estate tax. The federal estate tax is, and like the state estate tax, is a transfer tax, which means that it's a tax on the value of the assets that are being transferred from the deceased to the beneficiaries. One of the biggest misnomers about this is that it's a inheritance tax. I get this question a lot from people about, well, does this person have to pay estate tax because they're receiving the assets? And I have to answer them, in many, many cases, no, because we do not have an inheritance tax system.
Right.
So we're not taxed because we inherit assets. We're taxed on the estate. So the estate is the one that is paying the estate tax.
Yeah.
So that estate tax is a transfer tax. It's a tax on the fair market value of the assets. And so Washington state does have that individual state estate tax. Each taxing authority has an exemption. So you may have heard the federal exemption is super high right now, $11.58 million. So each one of us has an exemption for federal estate tax purposes of that amount. But unfortunately, the state of Washington exemption right now is $2,193,000. So $2,193,000. So that exemption basically is set right now. It is inflation adjusted, but it is tied to a non-existent indice right now. So it's really not going up right now.
Gotcha.
And it's set at $2,193,000.
Okay. So the idea, right, is everything above that, which is what you were kind of talking about earlier, everything above that's going to be taxed. Now, what can people, if people find themselves in that position, and especially around here, that happens pretty easily with home prices and things like that. If they find themselves in that position, what could they do on a high level to maybe start minimizing their estate or start, kind of minimizing that impact ahead of time?
Yeah, so there's a couple things depending upon whether or not you're married or single. So if you are single, one of the things we want to think about is first of all, do you want to stay in Washington state? It sounds funny, but that is an inherent question. Do you want to stay in Washington state, or do you want to choose to maybe move to another state where you don't have potential state estate taxes? Now, if you say, of course I want to stay in Washington state and I want to live here, then one option potentially is to think about gifting assets and to move assets out of your estate. Washington state does not have a gift tax system per se, as opposed to the federal system that does recognize gift taxes. So from a Washington state standpoint, it's relatively easy to transfer assets even before you pass in order to reduce the value of the estate. So as long as we don't have a gift tax system, that's one option. You do want to be careful, and that you should consult with your tax advisor and consult with your estate attorney dealing with those issues, because there's other issues if you choose to start gifting that you want to look at, including income tax issues.
Mm-hmm.
But it is an option to think about gifting. So that's one option if you're single. If you are married, one of the things that we highly recommend is, again, we want to make sure as a married couple that you take advantage of both exemptions. Each one of you has your own exemption. And to take advantage of your exemptions that happen, you really need to be crafting and creating an estate plan that'll allow that exemption to be used, which involves trust. And so when you are married and when you have an individual estate that's in excess of the threshold or close to the threshold, you should have some type of basic plan in place that allows you to take advantage of that through the use of trust within the document itself. It's got to be in the document. So that's important to have that. If you don't, then you really need to be reviewing your plan.
Okay, great. That's really helpful. So basically gifting or potentially looking at trust strategies to basically get it out, correct? Is that right? Either way, that's the goal. Okay.
Right.
Okay, well, I think maybe that's a really good place to wrap up here today. I think that kind of took it from the high level all the way down to, a little bit of detail too. So that was really helpful. I appreciate you spending some time to share some thoughts with us today.
Thank you, Brandon. It's good to be here.
Of course. If people do have some questions for you specifically, is there a way they can get in touch with you? And
yeah, you can always reach out to us at our law firm. So you can reach us at Rehberg Law Group. So I have an email address. It's jdavies@rehberglaw.com. Or you can always reach us at our phone number there in SeaTac and in Bellevue. We have 2 offices at 206-246-8772.
Awesome. Well, thanks again, Jim, for joining us today. Thank you guys all for joining us. I hope this is helpful. Again, our goal here is to provide some analysis, some expertise into those areas that we don't focus on day to day. Obviously, feel free to reach out to Jim if you have questions for him. If you have any questions for us directly, you can email us at info@mainsailfg.com. That's info@mainsailfg.com. Thanks again, Jim.
Thank you so much, Brandon.